So the DOJ's recent brief stating that suppressors are protected arms and cannot be outright banned is now being used in the Suppressor Freedom lawsuit, which aims to remove a statewide ban on the purchase and possession of suppressors. Now, before we jump into this video, I want to thank our sponsor, which is Attorneys on Retainer. When it comes to protecting yourself after a self-defense incident, AOR is in a league of their own. AOR is a real law firm, so they can help you in situations that maybe other companies would not. And right now, AOR is doing some amazing things. They've expanded their coverage to include new perks like civil liability coverage up to $100,000, red flag law coverage up to $15,000, and then also expungement coverage up to $5,000. Now, those are just some of the perks. They have a ton of other things that they've also added in. So if you want the most comprehensive coverage on the market, check out AOR using my link down below. And if you sign up using my promo code ARMSCHOLAR, you can get $50 off of your individual sign-up plan or $25 off of a family plan. As I mentioned in the intro, in this video, I have an important update for you in a lawsuit which aims to remove a statewide ban on the purchase and possession of suppressors. The case we're going to be talking about in this video is called Morris versus Raoul. This lawsuit was filed in a federal district court in the state of Illinois, and it aims to remove the state's ban on the purchase and possession of suppressors. This lawsuit can kind of be the first one in the nation, if it wins, to strike down these outright bans in states like Illinois, California, and others, and how these states have banned NFA items like suppressors. Currently in this case, the state of Illinois is trying to have the case completely thrown out at an early stage by arguing that suppressors are not protected arms under the Second Amendment. The state of Illinois is currently requesting that the judge here grant a judgment on the pleadings in the state's favor and throw this case out at the early stage. However, things just shifted drastically in this case because recently the Trump DOJ filed a huge brief in another case called U.S. versus Peterson. In that brief, the DOJ and the Trump administration shifted course for the first time really in a long time, and they admitted that suppressors are protected arms under the Second Amendment. They even went on to say that states cannot outright ban the possession and purchase of these items. This was huge, and it's now being used in this Illinois suppressor case. The state argues that suppressors are not arms and they can outright be banned because they're not protected. However, with this new position by the DOJ in the new brief that was filed in another case, the plaintiffs here are saying that the state of Illinois no longer kind of has a leg to stand on, that suppressors have been admitted as protected arms and a state cannot outright ban them. Now, in this case, the plaintiffs argue that suppressors are not dangerous and unusual items, and therefore the ownership of them cannot constitute the ownership of just a mere dangerous and unusual item. Instead, these are common arms owned by law-abiding people for lawful purposes. The state of Illinois recently, like I mentioned, filed a motion for judgment on the pleadings to try to get the case thrown out at an early stage. In the motion from the state of Illinois, they argue that the Second Amendment protects only the right of the people to keep and bear arms. Silencers are not weapons. They are not used for self-defense, and they are not necessary to the effective use of a firearm. So they are not arms within the meaning of the constitutional text, and thus plaintiffs cannot prevail on their 2A claim. They went on to state that while an instrument need not have existed at the time of the founding to fall within the amendment's ambit, it still must fit the founding era definition of an arm. But a silencer is not itself used to cast at or strike at another. It does not contain, feed, or project ammunition, and it does not serve any intrinsic self-defense purpose. And while some people find silencers useful, they are not so critical to firearms ownership that firearms cannot be used effectively without them. Silencers are therefore not arms within the original meaning of the constitutional text. So that is what Illinois argued. They went on to state that silencers do not satisfy the definition of an arm. A silencer is a firearm accessory. It is not a weapon itself. So the state's primary argument in their brief and in this lawsuit are that suppressors are not bearable arms, they're not protected arms, they're not a firearm within their own right, they don't shoot a projectile, and they're not necessary for the function of a firearm. At best, they say they're simply an accessory, but as accessories, they're not protected. Now, of course, that also contradicts the fact that at the federal level under the NFA, these items are treated as actual firearms, but the state of Illinois wants to ignore that. Now, the hearing happened recently in this case. There was a motion hearing, but that was temporarily put on hold because there were some developments in other cases in Illinois dealing with the Illinois rifle and magazine ban. Those were the challenges to the PICA law there that was passed in Illinois. So the judge here in the suppressor case wanted to put his case on hold until those, rifle bans and magazine bans kind of played out. Now, recently, Judge McGlynn on the PICA cases, struck down the Illinois PICA ban. He struck down the rifle ban and magazine ban as unconstitutional. Now, currently, those are also being litigated at the 7th Circuit level. But after that happened, the judge here in the suppressor cases decided to open them back up, let them move forward, and he heard a hearing on the motion. Now, when the suppressor case was opened back up, the state of Illinois tried to submit a supplemental notice of a related case, and that was revolving around the 5th Circuit decision in the U.S. versus Peterson case. Now, if you're not aware, the Peterson case involves an individual who had a gun store at his home that was raided by the ATF. And during that raid, they found a single solvent trap that was not registered, it was not serialized, and because of that, he was convicted of violating the NFA. But because of that, he decided to challenge the NFA based on the Second Amendment. He tried to get his charge dismissed based on the Second Amendment. However, the district court on review denied that motion, finding that silencers are not bearable arms protected by the 2A. Now, that decision was then reviewed by the 5th Circuit. A 3-judge panel took a look at that case, and they still ruled against Mr. Peterson and ruled in favor of the federal government. Now, the interesting thing about that is you still had the Biden administration making the arguments that suppressors are not protected arms, that they are not under the Second Amendment, that they're simply accessories, and that they're non-necessary, they're not useful for the function of a firearm. And so you still had the Biden administration making those arguments, but now a lot of that has shifted. In the prior notice, Illinois relied heavily on what the federal government had said prior in the Peterson case and what the 5th Circuit found on their review of this case, again, that suppressors are not protected arms. However, the DOJ has now shifted course in the Peterson challenge, and now since the Trump administration has controlled this case, they have changed their policy when it comes to suppressors. In the recent Peterson brief, the DOJ stated expressly that, in the view of the United States, the Second Amendment protects firearms accessories and components such as suppressors. As a result, restrictions on the possession of suppressors burden the right to keep and bear arms, and a ban on the possession of suppressors or similar accessories would be unconstitutional. The government's earlier argument to the contrary was incorrect. Now, this means that Illinois relying on the decision in the prior federal government's arguments about suppressors kind of just blew up in their face. The plaintiffs now in this Illinois suppressor case have pointed to this new brief from the DOJ, the new statements, and they're using them essentially as support for why the judge here in this case should not only strike down this Illinois suppressor ban, but allow their case to proceed forward. The plaintiffs in the suppressor case recently filed a new notice to the court, and they stated that on May 23rd, 2025, the Department of Justice filed a supplemental brief attached which explained that suppressors facilitate the constitutional right to keep and bear arms, and that restrictions on suppressors impose a burden on using firearms that implicates the Second Amendment. Additionally, the Department of Justice stated that a complete ban on suppressors would be unconstitutional. So the DOJ's recent brief on the suppressor case, the reversal of their opinion on suppressors, is now impacting not just what's going on in the 5th Circuit, but also this Illinois suppressor ban case as well. It's going to be interesting to see how the judge in this suppressor case uses the DOJ's recent statements and change in policy. The federal government now has outright said that these types of bans are unconstitutional, that they do not align with the Second Amendment. And so the state of Illinois trying to rely on what the DOJ has been saying kind of just blew up in their face because the DOJ has shifted course. So this is something we're going to be watching closely, and it's going to be interesting to see how the judge uses these new DOJ statements on suppressors and ultimately if he's going to allow this case to proceed forward. So as we get more information, as it develops, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.